A lawyer and human rights activist, Henry Ogoli, joins me via Skype now from London to discuss this. Hello, and thank you for joining us on TVC News.
Thank you. Good morning.
Now, what's your immediate reaction after that court judgment saying that the Senate has the right to go ahead with the probe?
Of course, that is laudable. And yes, it must be commended. It will seem like the rights of the rule of law is arriving in the shores of Nigeria. To me, I consider it very proper and adequate.
Okay, so does this seem suspicious that the Attorney General of the Federation that initially said he had nothing to do with the reinstatement and promotion of Maina went to court to stop the probe?
It is rather unfortunate that a man in his position is the chief law officer of the Federation would take that route at all, and I'm not in a very good position to inform what must have or to state what must have informed that decision of him, but it's so good. I think the court judgment has done a very good justice to that.
So what do you feel about his stance that if the Senate wants to probe it, it has to be an open sitting so that all Nigerians will get to view and hear what all those to be called will have to say?
It's unfortunate. Yeah, in a way, that is adequate too and proper, and I don't see why the Senate could not grant that, because it is in the interest of the public that such information is available. If he's asking that, well, the right to fair hearing does not only apply in court, and it also means that the public must be able to assess such investigation, because at that stage it's still investigative, and you know, it has always been tried to say that if justice must be done, it has to be seen to be done. To ask for a public this, I don't think he did too wrong. He did anything wrong there.
Okay, for the Senate not to want to allow this, would you say that it could be some form of trying to control the situation in case of an outburst from the revelation?
You see, nothing in law or in life is foolproof. If the Senate advances, what is always necessary is what is reasonable given the circumstances of a case. Even in court, there are some cases that are prohibited or that are not heard in the open court, or rather heard in chambers, depending on the interest that is affected or that is at stake. So if the Senate would advance a reason, these are the reasons why we don't want to make it public. You understand, in Nigeria, it's very easy for people to grandstand, and the public understands that, and he himself too is put on notice as to why, if that reason becomes superior to his, I do not see any reason why he would not comply. So that is my position or my take on that. Yes, there are issues that may demand some sort of privacy of hearing or investigation, so that it may not jeopardize if that case is pending in the court. So there would be ground for the Senate too to adopt that approach. You know, so it's not always what is said, but how it is said. So that is my take on that as far as I'm concerned.
What about the revelation some times back that some of the recovered property and loot by the Maina-led task force, pension task force, have been relooted already?
Sorry, take that question again. I've not been...
Some of the recovered loot or looted property in the past recovered by Maina's task force already being relooted?
Well, recovery, the National Assembly has an explicit oversight functions which went very far and wide. So it gives them that supervisory power once corruption or fraud is anticipated. Yeah, when Maina was invited on that, they were exercising a constitutional right. I must be very serious on this. And it behoves on the Office of the Attorney General to submit and comply to that too. So I don't think the head, it's a constitutional power given to the National Assembly. That oversight function stretches so far and wide. And yes, the Office of the Attorney General simply should have complied.
Henry Ogoli, lawyer and human rights activist, thank you for your analysis on the news.